Speeches do not have the force of law, whether they're speeches by presidents or by division directors of the SEC. Decisions as to whether Bitcoin and Ether are or are not securities are, as a practical matter, going to be made by the federal courts if and when the appropriate litigation actually arises. Now, the logic in the speech may be persuasive to the court, or it may not be persuasive. But still, it's just a speech, and that logic will probably have to be articulated in a brief filed with the court, but it'll have no precedential effect. Again, unless the SEC takes formal rulemaking action, speeches and other pronouncements by the SEC do not have the force of law. Second, and perhaps most intriguing, Division Director Hinman's analysis depends upon his understanding of the state of facts regarding Bitcoin and Ether as of June 2018. What was his understanding of the state of facts? We don't know. Nothing in the speech has the division director explain what it is about Bitcoin or Ether that leads him to the conclusion that it's sufficiently decentralized. That's quite curious, because typically when the SEC adopts a rule or regulation, or when a court issues an opinion, there are findings of fact. The court will say, I find the following facts to be true, and based on those facts, I apply the law and I reach the following conclusion. When the SEC adopts a rule or regulation, it will typically say, we had hearings, we looked at a record, these are the facts that we find, and because of these facts, we're going to adopt the following rule. Well, here we have the conclusion that Bitcoin is decentralized. We have the conclusion that Ether is decentralized. We don't know the facts upon which the division director is relying. That creates quite a mystery, because there are many people out there that are going to want to build crypto and argue that their crypto is not a security, and they're going to want to argue that if Bitcoin is decentralized and if Ether is decentralized, we're also decentralized. But if you don't have the foundational facts supporting that conclusion, how do you make that argument? Other problem with that approach are the facts upon which the division director is relying all of the relevant facts, or are they even accurate? There's no evidence they took evidence from people under oath. We don't know where those facts come from. Was it that they read a bunch of stuff on the internet and believed everything they read on the internet? Was it something else? And do they know all the relevant facts? For example, there's a site that you can go to that gives you the distribution of hash power on blockchain, on the Bitcoin blockchain. And it turns out that if you have more than 50% of the hash power, you can do something called forking the blockchain, which changes the rules, which in effect gives you a tremendous amount of control. Well, the data show that recently between 52 and 54% of the hash power is controlled by 3 different groups of Bitcoin miners, and all of these Bitcoin miners are in China. So the ability to fork the blockchain and to control the Bitcoin blockchain effectively exists in 3 different entities, all subject to the same government's control. Now, does that satisfy the definition of decentralization? I don't know. Did Hinman know that those were the facts? I don't know. We don't have any finding of facts, which makes this a very, very difficult situation for other people attempting to look at this as precedent and comply with the law. Third area that's problematic, the actual articulation of the law. There's no precedent of which I'm aware that looks at decentralization as the primary factor in determining whether an instrument is a security or not. And I could actually take the Hinman speech and argue it doesn't go far enough, or argue that it goes far too far. The argument that it doesn't go far enough is simple. Many courts are taking a textualist approach to the interpretation of the law. If we look at the law from a textualist perspective and we look at the phrase investment contract, the word contract jumps out at you. There's got to be a contract in order for there to be an investment contract. The orange is not a contract. The orange is not a security. The combination of the management contract with the land sales contract, that's a security. Well, if you look at Bitcoin, there's no contract. It's like the orange. If you look at Ether, there's no contract. It's like the orange. Bitcoin and Ether, from that perspective, aren't securities because they're sufficiently decentralized. They're not securities because they aren't investment contracts because there aren't any contracts. And by that logic, if that's right, and we don't know that it is, then many other forms of crypto will be able to argue we're not contracts either, and if we're not contracts, we can't be investment contracts, and therefore we're not securities. So there's a path that we can follow that argues that Bitcoin and Ether aren't securities for reasons that many other forms of crypto can also use to argue they're not securities. Now, I can also make an argument that cuts in totally the opposite direction and that says that Hinman is entirely wrong and that Bitcoin and Ether clearly are securities. Why? Let's go back and let's take the traditionalist approach. We have an investment of money. There is commonality. True, there's no vertical commonality, but the courts say that vertical commonality isn't necessary. True, every case of which I'm aware involves a promoter or issuer, but that's only because the state of technology that's existed until now. Until the invention of the blockchain, you couldn't have anything that would satisfy all of the Howey elements unless there was a promoter. But none of the cases say there must be a promoter, even though there always is a promoter. Intriguingly, with Bitcoin, you can trace these transactions if you're sufficiently sophisticated. Want evidence of that? Really easy. Have a look at the indictment that Mueller's office issued against the 12 Russian hackers on July 13th, 2018. If you read that indictment, there's very specific information there about how the Russians paid for servers and for other aspects of their hacking activity with Bitcoin. Now, how is it that Mueller's office would know that certain servers and other services were paid for with Bitcoin? Simple answer. They're able to read the blockchain. They can follow the transactions from one wallet, which has a public number, to another wallet that has another public number, and using other sources, they're able to figure out who's behind the wallet, and they're able to figure out the names of the people behind the wallet. Simple story. If the Russian hackers can't hide their identity from Mueller's office, neither can you. So, Bitcoin is not really anonymous vis-a-vis the ability of sophisticated parties to read and to analyze the blockchain. Intriguingly,